This one's a little bit out there. Probably not a super unusual situation. And I'll go first on this one, and you can pass or you can answer on this. So, if a parent's made false claims about sexual abuse, then started taking full nudes of said child, what do you do? So, I'm going to deal with the first part first. False claims. So, if they're most likely going to CPS or whatever that agency is, and they're saying there's sexual abuse occurring. What you want to make sure you do is document the allegations, document the investigation, and if it comes back up again, you can go to the investigator, you can go to the courts and say, hey, we've done this before. A lot of times, the ones I've seen where it's repeat offenders, the story is the same every single time, and so it can be very helpful to them to remind them, hey, you've done this before. And I can tell you from talking to these investigators, once they've been involved in a case 2 or 3 times, there's really no changing their mind unless there's something egregious happen. And that's one of the things of calling these agencies when it's not actually an issue can actually harm your child if, God forsake, there is an actual issue. Now, taking full nudes of said child. So I would ask probably about 10 questions here to the client. What are the nature of these? If this is pictures of your 2-year-old in the bathtub or your 4-year-old running through the house, okay, these shouldn't be going out anywhere, but we don't want to characterize them as being sexualized. Now, if it's, say, your 14-year-old son that they're snapping naked pictures of while he's changing, or it is something that's inappropriate, that's something that, candidly, that's not even really a family court issue. That is a federal crime. So on the second part of that, what are the nature? Because if you run to the judge and say, look at these naked pictures I saw where they put a little picture over the private parts and posted on Facebook of an 18-month-old, if you run to the court with that, the court's kind of going to be, what are we doing here? So that's either a federal crime or it's something that's being overreacted to. Do you want to touch on that at all, Jake?
I would completely agree on the first part. You just have the boy who cried wolf. I mean, that's all it is. So if you document it, be transparent. Make sure. So in Kansas, you'll have 3 options of findings with DCF when there's been a report made. You'll have either an affirmation, which is pretty much the claims are validated, a substantiation, which means the claims are not confirmed, but there's evidence there. And then there's unsubstantiated. Anytime you get an unsubstantiation, that's a great thing. That means the claims are proven invalid. Keep that sheet of paper, make copies of it for your files, give it to your attorney, go screaming in the streets with it so everybody knows it was a false claim.
Yeah.
So then again, the next time that it arises, you can say, look, this is the fact pattern. This is the fact pattern. These were the same allegations 6 months ago. Nothing has changed. It was unsubstantiated then. It'll be unsubstantiated now, and that will direct DCF more than any other piece of evidence that they get.
Yeah, 100%. Save your documents. The easiest clients to advocate for are the ones where we have complete files and we don't have to go on a hunt, because some of these agencies like CPS, DCF, they can be challenging to get documentation from. So outside of your family court, if you have any other agencies involved, you need to hang on to those records because they can be challenging to get your hands back on.